Yeah, because it didn't look like it was that much, did it?
It was 80 out, but.
Well, I've been bitching for years, they'll file a law, file that many documents, and we never need them. So we gotta take a look at it.
Hi, good morning.
Can we mark out all the exhibits on there?
Thank you. Hello. No. I'm sorry?
This was, and then the only other two are me.
I have the. Simone. Simone,
Yes.
I'm going to keep you in the waiting room for a little bit. We have another hearing going, and we are waiting for the prosecutor for you, okay? And Mr. Bowditch, your attorney is with another client. So it'll just be a few minutes, okay?
No, it's 6 o'clock in the morning. Y'all just want to call me back.
It's 9 o'clock here. Where are you located?
Phoenix.
Okay, hold on. Miss Jackson?
Mm-hmm. Yeah.
All rise, we try. Ready for this courthouse session, Friday, present.
Good morning, folks. Have a seat. Well, nice and cool in here this morning. All right, people, appearance for Haggerty Holding versus Walker and Watts, please.
Good morning, Your Honor. Mark Chiaz on behalf of the plaintiff Haggerty Holding Court.
Good morning, Your Honor. Rula Owen on behalf of Yolanda Walker and Judy Watts.
Good morning, you two. Good morning, folks. Are we ready?
We are, Your Honor. My client's running a little late apparently, but we
Okay.
can proceed.
If you can get started without, sure. Any objection?
I planned on him going first.
So
If you want to handle any other hearings.
I've got some stuff that's almost ready, so I got no problem waiting on it.
Okay. Thank you.
Okay, so just settle back. I'm filling out a survey today from Scale. The Supreme Court wants us to tell them about Zoom. That's great timing.
Judge,
Yeah, Heather.
both Simone and Kaplan are in the waiting room. Did you want me to bring them in?
Has she, yeah. Do you know, has she asked for an attorney?
No.
Okay, that's fine. Bring him in.
He's not doing it. So.
I think they're going right to the courtroom.
Yeah, we're back. We're not private now, but we're back together. We'll be together in the courtroom in a couple minutes.
Jeff, do you need more time in a breakout?
No, Your Honor, we're ready.
Dan, go get the white file off my office chair.
Why do you lose so much time on camera?
All right, Mr. Bowditch, I do not have the file in front of me, so what's the gentleman's name?
The gentleman's name, Your Honor, is Rashid Thomas. Last name.
Good morning,
Thomas.
Mr. Thomas.
Good morning, Your Honor.
And would you waive formal reading?
Your Honor, for the record, Jeffrey Bowditch appearing on behalf of him with Mr. Thomas. We would waive formal reading, stand mute, ask the court to respectfully enter a not guilty plea.
Thank you. Mr. Thomas, do you have a good phone number I can put on your file?
Yes, Your Honor. 248
Go ahead.
915 6866.
Was that 915-6866?
Yes, Your Honor.
Thank you, sir. All right, pretrial date on this file is going to be August 24, 9:30 a.m., courtroom 3.
9:40, Your Honor.
930, 930.
9:30. Thank you, Your Honor.
You're welcome. And Birkdale Drive is a good address for you, sir?
Yes, sir. Yes, Your Honor.
All right, Mr. Bowditch, the police department is asking for a no contact and not to return to the Birkdale address. What should I consider before I set the bond?
Well, Your Honor, before you, in my opinion, is a hell of a guy. He's in the situation he is, but he's a 34-year-old individual. He's an electrical engineer. He's unemployed at the time. Last time he worked was in June, and he's anticipating another job in the next week or so, hopefully. He's not on probation. He's not on parole. He has no warrants. He does have, with Miss Chelsea Thomas, 8 children. He's a he's a veteran, served in the Army honorably, went on 3 deployments, and he's presently been in custody for 3 days. I would hope that the court would consider a personal bond in this matter.
All right, Mr. Thomas, thank you for your service, sir.
Thank you, Your Honor. I appreciate it.
Mr. Bowditch, did you say he had no warrants or he had warrants?
No warrants, Your Honor, and he's not on probation or parole. His only offense, unfortunately, is with the same woman 8 years ago, domestic violence.
All right. And Mr. Thomas, do you have somewhere to stay other than the Birkdale address?
Yes, Your Honor. Can I further elaborate on that question that you asked me?
That would be up to Mr. Bowditch.
Your Honor, we have already discussed this. There is a matter that he wishes to bring to the court's attention. I know what he's talking about.
Okay, go ahead, sir.
Your Honor, I believe I do have another place to go from here, which will be in Brighton, Michigan. Unfortunately, due to the current circumstances, of course, with the 8 children that we have inside the home, we don't have a strong support system that's able to help facilitate the day-to-day activities and care for the children. So Miss Chelsea is in nursing school as of the moment, and her class schedule times are from 8 a.m. to 12:30. And at that moment, there will not be anyone inside the house to watch or take care of the younger children other than a 17-year-old child who's not necessarily an adult himself, who's also had his own run-ins with the law. So I was trying to figure out there's some way to facilitate that and the sharing of the vehicle use without that contact happening, whether it's facilitated through the police department or civil standbys or anything of the accord to where it allows me the opportunity to at least be with the kids when she's not there. That way they have someone to watch them and then leave after she returns or leave before she returns.
Who's there for Romulus PD today?
I'm sorry?
I asked who's there for Romulus PD today?
Officer Long, Your Honor.
Did he leave the room, Mr. Thomas?
No, Your Honor, he's right here beside me.
Good morning, Your Honor.
Oh, it's not Romulus. That's what threw him off.
No, it's me here. Hi, how are you?
I'm looking at Josh on another screen, so I got Romulus on my brain. Mike, we're obviously not going to do civil standbys every time they want to switch cars.
Correct.
Do you have any input that might assist with that?
In a discussion with them, it sounds like she has an alternative place to stay as well. There's a coming and going between the both of them. I'm not sure how they'll be able to manage that on their own. Obviously, we just don't want the conflict.
Yeah.
If she can stay at her mother's, that would be great. But I think I don't know how we're going to manage that both ways, though. I think there's going to be some resistance on her side.
Yeah, the township's all right with him being at the address as long as there's no contact between the parties.
Correct.
Is that what I'm hearing?
Yes.
All right, Mr. Thomas, thank you. Mr. Thomas, if there's some way that you can facilitate that, maybe Mr. Bowditch can assist. I'm not going to order that you not go back to the Birkdale address. I'm just going to order that you have no contact with her. You can set up a civil standby one time if you want to go back with the PD to pick up some personal items or something like that, but they're not going to facilitate, vehicle exchanges every day or two. They can't do that. They don't have time for that.
I understand that, Your
Mr.
Honor.
Bowditch, anything else before I set bond?
Nothing, Your Honor.
I don't think I said it for the record, Mr. Bowditch, but I am going to enter a not guilty plea for Mr. Thomas.
Thank you, Your Honor.
I am going to put you on a personal bond, Mr. Thomas, with a couple conditions. The first one is obvious. Cooperate with Mr. Bowditch so we can move this case along, have a meaningful pretrial date on August 24th. No contact with her, no phone calls, no letters, no social media contacts. You see her Taco Bell, you're eating burgers. Don't have your friends call and check on her. Just no contact. Understood?
That's easy enough, Your Honor. I've been in that situation before and never violated it.
Okay.
Mr. Thomas.
Raise your right hand for me, sir.
Oh,
Go ahead,
I'm sorry,
Mr. Bowditch.
I was just going to tell Mr. Thomas he doesn't have a pen or anything with him. I will be, now that I'm on the case, I will be calling Mr. Thomas and giving him my phone number.
Okay. Got that, Mr. Thomas?
Yes, Your Honor.
All right, raise your right hand, sir, so I can put you on a personal bond. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $2,000 if you violate bond?
Yes, Your Honor.
All right, thank you. Good luck.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, officer.
Mike. Stay safe.
Thank you.
Thank you, everybody.
Simone Jackson, are you connected?
Yes.
Good morning. Mr. Kaplan, your appearance for the city of Romulus?
Your Honor, Joshua Kaplan on behalf of the city of Romulus.
Now, Your Honor, Jeffrey Bowditch, 45367, appearing on behalf of and with Ms. Jackson.
Thank you. Mr. Bowditch, do you need a breakout with Ms. Jackson?
Yes, Your Honor, if I could.
Jeff, I just
All right,
sent
would
you
you like
via
to-
email the police report. I apologize, Your Honor, but I just want to let Jeff know
That's
there's
all
a
right.
police report.
You catch that, Mr. Bowditch? The police report's been sent to you via email.
Yes, Your Honor. There's usually not a police report in these matters.
This is not a truancy issue, Jeff. This is something other than an attendance issue.
Oh, okay.
Do you want me to
That's
put you in a breakout room right now?
Yes, ma'am, that'd be
Hold
fine.
on just a minute, Heather.
Oh, okay. Thank you, Judge.
Miss Jackson, gentlemen, I'm going to put you all on mute while I start another in-person hearing. Mr. Bowditch, when you're ready to talk to me, just give me a thumbs up and I'll see you on the screen and we'll get you on as soon as I can.
Yes, Your Honor.
All right, now you can put him in a breakout, Heather. All right. Counsel, are we ready?
Yes, Your Honor.
Okay. All right, I got your appearances. And
Yes.
you two don't have to jump to talk to me. It's okay if you do. I know it's instinctive, but you don't have to. As long as Heather can hear you clearly, I'm not going to think it's disrespectful if you're sitting down.
Okay.
Go ahead, Counsel.
Your Honor, if I may, I'm sorry to interrupt.
Sorry.
I was just speaking with my client and I was hoping to just address a preliminary
Okay.
item. I wanted to make a motion to dismiss.
Okay,
Okay.
go ahead.
So, sure. So this matter was filed sometime in April of 2021. My client had already vacated the premises back in February of 2021. So the fact that this action was brought as summary proceedings is not appropriate. MCL 65701 at SEC lays the grounds for seeking summary proceedings, and due to the fact that my client was no longer on the premises, she had already vacated. It's our position that there isn't a claim to be stated here in this action. Moreover, with respect to the money damages, my client was not personally served, and MCR 4.201G requires that my client be personally served or in accordance with 2.105 for a money judgment to apply. So we don't believe that there's anything left to address.
Counsel, just a clarification. You said your client. Are you referring to
My clients who are here today.
both?
Yes,
Both.
both of
Okay,
them.
I just want to
Neither
make
of
sure you're
them-
not speaking. Yeah,
Yes,
okay.
neither of them were served with a money judgment claim, and
Okay.
because they were not on the premises, there's no need. for
Okay,
something
I got you. I
else.
just want to clarify that for the record.
Yes,
Thank you.
thank you.
Your
Counsel?
Honor, if I may, again, this was started as a non-payment of rent case or seeking possession. My clients were unaware that the defendants had vacated the property. Again, there will be an offer of proof of a letter that was purportedly sent to my client. He will testify he never received it. So based upon the fact that it was his belief they were still residing in the property, we filed it as a possession non-payment of rent. As for the service, I believe it was paid for through one of the court officers. I don't have that immediately available, but I didn't think it'd get to this far unless there was in fact personal service. Obviously, there was a preliminary hearing regarding this motion, regarding this hearing, and again, it wasn't brought up at that time. So again, as far as I know, there was personal service.
Let me see if I can find anything in the file.
Your Honor,
Yes, sir.
obviously, again, I don't have anything to verify that, but even if there was not, again, I think that's one of the issues that has to be raised at one of the, first hearings. I think we've had at least 2 pre-trials on this case. So I think it's, past due, and I think it was waived.
I think you might be right, but I don't have a court rule in front of me. Proof of service signed by Officer Rossi. Service by attachment. So, counsel, given the fact that this was kind of a last minute issue raised, I'll give you some time if you want to do a little research and see if your assumption and mine is correct. To be honest with you, I don't know that I've ever had this issue raised in 22 years. If I have, it's been so long I've forgotten it. So do a little research and see. It seems to me this is something that's supposed to be brought up in the initial pleading. Let's just take a break. I'll give counsel a chance to do some research.
Thank you.
Well, 21 work on 22. Yeah, I don't know how that happens. Just go so far.
They served by attachment. And that's not personal service. So the question is
Again.
Heather?
Yep, do you need to speak to Josh?
Yeah, let me speak to Josh for a second.
All right, let me put you in a breakout room.
Thank you. Is the judge still doing something live?
We're taking a break on the live right now, but yes, we are still.
Oh, all right.
All right. Simone, can you mute yourself for right now, please, just while we're waiting? Thank you.
bowling. Person. Alright, so oh shit. All right, that's fine. That's fine. Well, that's fine. This isn't a personal jurisdiction issue. It's a money judgment issue. Whether I'm money. Well, good. I prepared both ways.
Are you guys good? Ready for the judge now?
Ready
Yeah,
for
we're
the judge, ma'am.
All right, just 1 second. Mr. Bowditch,
Yes, ma'am.
for the no contact on Mr. Thomas, he was
Yes, ma'am.
was he able to return to his residence?
Yes, he was able to return to 42852 Burkdale as long as he didn't have any contact with the missus.
So she
And-
does not live there.
Well, they both live there, but
Both live
he
there.
said when they fight, she goes and stays with her mother. Now, these two have 8 children and just no babysitters. So one of them is always watching one of these 8 kids.
Okay,
So he was telling the judge that these aren't, I mean, these are high class people. He's an electrical engineer. She's in nursing school. And,
Okay.
and so it's not your usual. So the judge was very sympathetic and said, if you can find a way to go back to the home and babysit, and then when she gets there, you leave, and they also share a car. Oh, that's a mess.
Okay, I just wanted to verify. So it was just no contact with her.
Just no contact with her. He's allowed to return to the residence if he can.
Okay, thank you.
Yep.
Stacy, that's all right. He's got to walk faster than me if he wants you to stand up. That's your problem. Okay, folks, you can all unmute. Ms. Jackson, you think maybe you can stop doing dishes just for a minute while we take care of this court proceeding?
Huh?
Could you maybe stop doing dishes for a minute while we take care of court?
Okay.
Mr. Bowditch, where are we at?
Your Honor, Ms. Jackson is a resident of Arizona. She has no plans of coming back to Michigan. She is requesting a trial, so it would have to be by Zoom.
Unless I require her presence in Michigan for the trial.
Exactly. It would be her request, Your Honor. It would be Zoom.
All right. Is there any reason why we could not handle this one by Zoom, Mr. Kaplan?
No, Your Honor. If that's what Ms. Jackson wants, we would have no objections.
Okay.
And if that's what you allow.
Heather, give me a date for a bench trial.
All right. We have, even though it's a Van Buren on Thursday, September 2nd, is that a rhymeless date for you, Josh, already? I know it's not with us.
Yeah, I'm with Judge Green that morning, and then I have a
Heather,
trial.
September 2nd wouldn't be good for me.
Oh, okay.
I have other stuff on that day.
Tuesday, August 31st. You don't have anything on the docket right now, Judge?
Okay.
I'm available that day.
That would be fine with me, Judge.
You want to do it like 11 o'clock in the afternoon?
It would be
in the
better
morning?
for Miss Jackson, Your Honor. She's on Arizona time. It's 6 a.m. there as we speak.
What date was that?
That's Tuesday,
31st?
August 31st, correct? Or we have Monday, the 30th also, whatever's best.
We can do 2 o'clock in the afternoon on Tuesday, the 31st, if that works with everybody's schedule.
Works for me, Your Honor.
Mr. Kaplan?
That works for me, Your Honor. Yes, Your Honor.
All right, Ms. Jackson, any objections to 2 p.m. on the 31st?
No, that's fine.
And
Have a
that's by
lovely day.
Zoom?
Zoom.
Thank you.
Mr. Bowditch, we've got another Huron Township case for you. We're going to have them come into the meeting so we can get you a breakout room.
Thank you, Your Honor.
Thank you, Your Honor.
Mr.
Thank you, Josh.
Kaplan, enjoy your day.
You too.
I
Thank you,
called
Josh.
Andy and she said it's going to be about 5-10 minutes for Huron. They had to pull somebody off the road to come in.
Got it. You hear that, Mr. Bowditch?
Yeah, I'm ready anytime anybody is.
Thank you. All right, back on the record with Haggerty versus Walker. Mr. Chessie, Chessie or Chessa?
It's really Chiazza, but Chiza.
Chiazza? Chiazza. I'll say it your way. Did you find anything?
Yes, Your Honor, if I may, and
Please.
if I may use my.
Oh, absolutely.
So.
It's 2021, right?
MCR 2.108A5 specifically states a party served with a pleading to which a reply is required or permitted may serve and file within 21 days after service of the pleading to which it is directed. I'm not sure I ever received an answer to the complaint whatsoever. Furthermore, 2.116C3 lists some specific grounds for dismissal. One of the grounds is C3 states the service of process was insufficient. 2.116D1 indicates that the grounds listed in subrules C1, 2, and 3 must be raised in a party's first motion under this rule. Again, this is the first time it's being raised. It's too late, and as a result, the case can proceed.
All right, Ms. Owen, response.
Yes, so it did say that it was to be raised in its first motion. This is my first motion. Notwithstanding, I am also looking at the residential landlord tenant law bench book, which says disposition of a claim for a money judgment requires the defendant be served as permitted by MCR 2.105. If service of process under 2.105 is not made on the defendant for a money claim, the money claim must be dismissed without prejudice or adjourned until service is complete. I'll say that.
Response?
Your Honor, again, I think that there's been a waiver of that, given the fact that there's been 2 previous pre-trials. We have an appearance by an attorney. And I mean, I could move for a default if that's the game that they want to play. The fact of the matter is any type of pleading requires an answer be filed. They never filed an answer within 21 days. I mean, I could move for a motion for summary judgment based upon a default. Again, if we're getting technical, the fact of the matter is I believe the case can proceed based upon her appearance at 2 previous pre-trials. And then again, in terms of judicial efficiency, we might as well proceed. This day and time set for trial is going to take the court 1 hour probably, or 2 at the most, rather than go through all the procedures of refiling and all that. I think that's not even necessary because I think we're legally, before the court.
Go ahead.
And Your Honor, I am prepared to proceed also. I just wanted to preserve that objection on the record.
All right. We're gonna proceed. Counsel, this could sound like I'm chastising you, and I don't mean it to sound that way, but I don't like the idea that I've wasted 3 court dates of my own before hearing this.
That's correct, Your Honor, and it was pursuant to a discussion I had with my client yesterday where she did tell me that she was not personally served, and that's what rang that bell. It is my fault, I agree. That's why I'm ready to proceed in the
Okay,
alternative.
let's get going then. I deny that motion. Let's get going.
At this time, the plaintiff would call Arvel Krishna.
Mr. Krishna, all the way up front. Raise your right hand for me. Swear or affirm. You're gonna end up here, but you can raise your hand wherever you want to. Do you swear or affirm, tell the truth, the whole truth, nothing but the truth today?
Yes.
Have a seat right there. Make yourself comfortable, state your name, and then spell your last name for Heather, if you would, please.
Krishna Arval, last name is Arval.
A-R-V-A-L. Arvel.
Yeah.
Did I say it right? Arvel? Arvel?
Yeah.
Did I say it? Okay. Go ahead.
Thank you. Mr. Arvel, what's your association with Haggerty Holding Corp?
I'm the principal officer and a partner of the company.
And Haggerty Holding Corp is the entity that either runs or owns 9459 Essex.
Yes.
And you're familiar with this property?
Yes.
I'm handing you what's been marked as Plans Exhibit number 1. Can you tell the court what that is?
This is a lease which was signed in December of 2019, I suppose, December. If I can see the date and tell you.
The signature page shows December 4th, 2019.
Yes.
And this is a lease between Haggerty Holding Corp. And Miss Yolanda Elaine Walker and Judy Marie Watts.
Yes.
And it was signed by yourself as on behalf of Haggerty Holding Corp. As the landlord.
Yes.
And it appears though you only received one signature, and that's Yolanda Walker Upshaw.
Yeah, only she could sign it because she was in my office when she signed it.
Okay. And this is for the property at 9459 Essex.
Yes.
Located in the city of Ramos.
Yes.
And pursuant to this lease, how much rent were the tenants obligated to pay?
It is 1,300.
Did you, are you aware that they made an application to the Michigan State Housing Development Authority?
When she was signing this lease, she said she has a voucher which is approved for that kind of amount, that she can pay the full rent. That's the reason she signed the lease.
And so did you receive some payments from the MSHADA?
Can you come back with that question?
Did you receive some payments from the state of Michigan?
Yeah, I received payments from the state of Michigan.
Okay.
But that's also a long story here. Sorry if I have.
No, just stick to the question and answer.
The question is, Michigan State paid.
Sir, I don't want narrative. I don't want a storytelling time. Answer the questions from counsel.
So in addition to the monies you received from the state of Michigan, did you also initially receive some payments from the defendants?
The defendant, I suppose, paid 3 payments other than the security deposit.
What was that last comment, other than?
The security deposit payment.
Security deposit.
Were you aware whether there were any issues with the property? For example, did you get, was there an issue with the front porch?
The property had no issues. After she moving into the property, within the first month and a half, there was a drainage issue. So we had to get the sewer done. They had to dig open the front porch, and they did it. Subsequently, we fixed that. But the front porch modification has nothing to do with the inside of the property.
Okay, correct. I mean, again, there was a problem with the front porch, you applied for a permit, you got the porch fixed.
Yeah.
Were you aware of any complaints regarding the wiring to the microwave?
No,
Are you aware of any other major problems with the property?
no.
I have nothing further at this time, Your Honor.
Your witness.
Your Honor, would you prefer all the
Either-
exhibits at once?
However you want to handle it.
Okay, I'll just keep them for you based on what I seek to admit. Okay, I'm sorry, I didn't hear what you stated your position was with
The principal
Haggerty
officer
Holdings.
as well as the partner of the Haggerty Holdings.
Okay, so you're the partner, and you're familiar, you said, with the property. Can you describe this property?
What do you mean by this?
Is it a house, a condo,
It's a single family
apartment?
home. It's a single family home.
Single-family home? Okay, and you're the person who had supervision of the premises
Yes.
during the time my client lived there? Yes?
Yes,
Okay, and were you the person who collected rent?
I didn't collect the rent.
Okay. Had you ever had any contact with my clients before they moved into the property?
Yes,
Okay. Is it correct that this tenancy was through the rental housing program with Mishta?
the tenancy was not through the RPA management or the Mishka. She approached us saying that she had a voucher, she wanted her to support it. And that's the reason the whole process was adopted, and we did go through that.
Okay, and you're familiar with RPI management?
That was the first time we ever dealt with RPA management.
Okay.
I was not familiar with them, but we did go through the process.
And were you in communication with RPI prior to my clients moving in?
No,
Never? Okay, did you, actually, I'm going to show you this document. Are you familiar with this document?
yes,
Okay, when did you receive this document?
I didn't receive this document, what you're showing me.
Okay, this is a document from RPI management, and it states that it's a request for tenancy approval. Is that correct?
Is it an email or is it a physical mail document? Because the first email that I received from RPA management was in the January of 2020, for which I have a copy, where the communication started from there.
Okay, so this communication is dated December 5th, 2019. And this document states, where I've highlighted, that the following corrections are needed. Rent renegotiated from $1,300 to $1,002. Is that correct?
I'll give you the correct copies. Mark, do you want me to give the copies?
I'm
or-
just asking about this
No.
document. This
I'm
says
not
that the
aware.
rent is renegotiated from $1,300
No,
to
not of
$1,002.
this. I said no to this document.
That's not what this document
No.
states?
That document I've never received, ma'am.
Okay. Okay, so you didn't receive this document, which states that the rent is renegotiated from $1,300 to $1,002. Did you modify the lease agreement that you say was initially signed December 4th of 2019?
The lease corrections were done in the March of 2020, when RPA management sent us asking for a correction of the lease. Reason being, they said she was not entitled to get that rental support that she initially promised us. They wanted a correction to be done. At the same time, there was a COVID situation. At the same time, we did ask Iwanda to move out of the place. We gave her a notice to move out. Because of the COVID crisis, RPA management spoke to us. It is going to be too difficult. They asked us to adjust it. We did the lease corrections, and Iwanda subsequently signed one more document which very clearly says that she is going to pay the balance, the difference of the rent from
Okay.
this lease and the other lease.
So my question then was this lease corrected from the rental amount of
It was
$1,300 to
corrected.
$1,002?
It was corrected.
You have to wait until she's done asking the question before you answer it.
Okay, and I'm coming with Exhibit C. Are you familiar with this document?
I'm talking, you're again going back to a document which is dated in March, and it is not matching my documents here.
Okay, this is a document that's dated January 31st, 2020, which states the lease must contain the following items to be accepted. And it states there that the approved contract rent is $1,002. Is that correct?
The documents are same, but the dates are different.
Okay, sir, I'm just asking you about this Exhibit C, which I am showing you.
You're
It
showing
does
me the
say
Exhibit
that-
C with a date of 131, which I can
Okay.
only say, no, the figures are correct, but the date that I have the exact document is dated March 4th.
Okay, this document is from RPI and it says the lease must contain the following items to be accepted. Approved contract amount, $1,002. Is that what this document says?
Ma'am, again, I will not be.
Sir,
able to
that's
say-
a yes or no question.
No, sir.
Okay.
Okay, that's what that says. Thank you. Okay, so you recall that you did make modifications to the lease pursuant to the corrections that RPI had requested.
Yes.
Is that correct? Okay, coming with Exhibit D. This is, are you familiar with this document? Okay, this is a lease that begins on February 1st, 2020. Is that correct?
Yes.
Is that your initial on the bottom of
Yes.
the page? Okay. Is that your signature?
Yes.
Did my client sign this lease?
Shouldn't sign it.
Okay. But the tenancy begins February 1st of 2020. Is that correct?
Yes.
So do you hold that this is the correct lease that governed the tenancy?
From the date of position, yes.
Okay. So this is our lease that my client did not sign. Okay, I'm coming with Exhibit E. Sir, are you familiar with this document?
Yeah.
Okay, and this is a document from MISHDA, which states it's an adjustment notification. Is that correct?
Yes. Can you,
Okay, what is the contract rent amount?
can we, for the purpose of the court, can you tell me the date of the?
Sure, this is dated March 23, 2020.
Good. I
Okay,
got
and
it.
what is the contract rent amount?
102,
Okay, and what is the tenant contribution amount?
282,
And what is the housing assistance?
720.
payment? Okay, so my client is supposed to pay you $282 a month and MISHDA pays $720. Is that correct?
Good.
Okay, so I want to discuss the condition of the premises. Prior to my client moving in, was this property inspected?
Yep.
When?
It was inspected, if you just referred RPA management. RPA management did the inspection. They approved it on 31st of January.
Okay, do you have any documents showing that an inspection was
I will
performed?
ask Mark to get it. It should be there in the system today, but I don't have it.
Okay, I'm coming up to you with a document here. Are you familiar with this document?
I would like to ask you, how did you get my document?
Well, it doesn't matter how I
I
got it.
want, it is my personal, it is a document which is a communication between the city and my company.
Okay.
How did you get this document? You tell me, then I'll approve.
Okay.
I
this
think
is
that was a
document-
yes.
I'm sorry?
I think that was a yes. He's familiar with the document.
Okay, this is a document from the city of Romulus. Do you dispute that official city records are not accessible by anybody other than yourself?
I said yes, but I would like to know in the court, how did you get the document?
This was a document that was produced by my client. Like I said, it's an official city record.
Ma'am, this city records are between.
The city would give that record to anybody that inquired about that address. It's
Thank
a
you.
public record.
Okay,
It's a public record, fine.
sure. What is the date of inspection here?
19.
That's December 4th, 2019, is that
Yes,
correct?
yes.
Okay, and was this the inspection that you were just referring to?
No,
Or is there another inspection?
there was 4 other inspections done.
Okay, And then pursuant to this document, there were some inspection comments. Is that correct?
Yeah.
Okay, following this inspection, were you given a certificate of compliance?
Yes,
Okay, do you have a copy of that certificate?
I will give
of
it to you.
compliance?
Mark, you have a copy of it? The last inspection date of the February?
I was asking if you had a copy of your certificate of compliance following that inspection.
Right now, I don't have.
Okay, if I told you that my client had contacted the city of Romulus and there was in fact never a certificate of compliance, would you disagree with that?
Your Honor, I'm gonna object, that's hearsay. He's asking her for what her client was told by the city of Romulus.
Sounds like hearsay. Response?
No response.
Okay, new
Strike.
question.
Okay, so pursuant to the inspection that was either done according to this document on December 4, 2019, or as you say on January 31st, 2019, did the home pass an inspection?
Yes.
Okay, but you said you did get a certificate of compliance?
Ma'am, you're mixing up two things, Judge. This is just going around. As a landlord.
The question she asked was, did you get a certificate of compliance? That's a yes or no question.
She just asked me about.
Sir, don't argue with me or I'll dismiss.
I just said no.
There's your answer. No seal.
Was that a no?
No.
Okay.
No certificate of occupancy.
Okay. Is a certificate of compliance and certificate of occupancy, to your knowledge, two different things?
Two different things.
Okay, did you ever have either?
I have. The question, that's where I'm interested. Are you asking the RPM management for Section 8 housing inspection, which was passed on 31st of January?
She's asking about the certificate of the inspections from Romulus.
Romulus inspection certificates, I've already produced it to my attorney. She will get a copy.
Okay, so you're saying you have a certificate of compliance from the city of Romulus or a certificate of occupancy?
It's rental occupancies.
Okay.
I'm sorry.
On the record of the court, the house had all the legal certification for the tenant to occupy the house. And it has passed all the inspections internally for the safety and requirement and Michigan State Act.
Okay, I understand, but so I had asked if you had a certificate of compliance and you stated no.
Can you ask me? You're asking me, I said no.
Okay.
And where are we going?
Okay, then I'm going to, are you familiar with the Romulus City Code of Ordinances?
Okay, if that is what it is.
Are you familiar with the Romulus City Code of Ordinances?
Yes, go ahead.
Okay. And pursuant to Section 8-240, no person shall lease, rent, occupy, or otherwise allow a rental unit within the city to be occupied unless all of the following requirements have first been met and a valid certificate of compliance being issued by the department is one of those conditions.
I have a temporary certificate of occupancy which was issued. The inspection reports are there. The inspectors have signed. You should have gone into the city and checked up a whole file record of it.
Okay. Did my client ever contact you about the condition of the premises?
No.
Never?
No.
Not via text message?
She had sent me text messages which are on the record, and I don't know if my attorney has given it to you.
So she did contact you about the condition of the premises?
Condition is whatever repairs she asked, those were all undertaken.
Do you recall what her complaints were?
What her complaints were, there were a sewage issue, a drainage issue which was corrected. Both were taken care of.
What other issues?
No, what I'm aware of, I've already told you.
So she's never complained about anything else other than a sewage issue, a drainage issue, and as you had stated to counsel when he was questioning you, the front porch, which is external.
Front porch is a part of the drainage correction which was corrected.
Okay, how many times did either yourself or you send someone out to the premises to make any corrections or repairs?
About 8 times.
Okay. During her tenancy, were you ever sent notices from the city of Romulus regarding any violations on the property?
It's a yes or no question?
No.
So
You never were? Okay. Coming forward with this document, are you familiar with what this document is, which is marked as Exhibit G?
This document, I've not received it.
Okay. This is a document that is from the city of Romulus. It says property maintenance, and if I read from it, it said it's been brought to the attention of this office that there are violations of the 2015 International Property Maintenance Code at the above referenced address, which states 9459 Essex. Is that correct?
Yeah.
Okay. Did you ever receive any other inspection notices?
No.
Be clear, from the city.
Because-
From anybody else other than the city of Romulus?
No.
Okay, I'm showing you what's been marked as Exhibit H. Are you familiar with this document?
No.
Okay, this is a notice of inspection from Mishta, is that correct?
Yeah.
Okay, and the date of the inspection is June 29, 2020, is that correct?
Yes.
You were never notified that
No.
the inspection on the property was to be conducted?
No.
Okay. Were you ever advised that your city certification had expired?
Yes.
When?
This was in December of 2019.
I'm showing you a document from the city of Romulus. Are you familiar with that document?
July of 2020, no, this document.
Okay. This is a document from the city of Romulus stating an internal audit of our records reflect that your city certification inspection conducted at the above referenced address expired on April 23rd, 2018. Is that
No,
correct?
there was a subsequent, for number one, you got to refer to the date. It's the July 22nd date you're showing it to me. I have not seen this letter. Okay, number one. Number two, if this is what is the city is talking about, I should ask the city to come and address this code.
Okay, so, and it also states in this letter, building and electrical inspection of the structure and premises was conducted for compliance with city codes. Building inspection has not been approved. Is that what that says there?
Ma'am, it is like a letter which I have not received it.
But it's addressed to
It can be anything.
16370
It can be anything. I have not received it. And I would like the city to, inspectors to come and answer this code.
Okay, it's
Because-
addressing a property.
Ma'am, again, I'm trying to tell you, if you're, I cannot say, I have not received that letter, no.
Does it address the property at 9459 Essex?
You're showing me something that I've not received.
Sir, you're making this very difficult on everyone, including you, because you're not answering the questions that I will just.
I'm coming with what's been marked as Exhibit J. Are you familiar
Council,
with
give me
that
just a minute. My
document?
Zoom is doing something.
No.
else.
Yeah, I don't know what's going on, Judge.
Yeah, it just shut down and then opened up again. Did Mr. Bowditch get time with his client?
No.
Yes, Your Honor, we're ready.
All right, why don't, this is a good time. Let's take a break. Let the witness opposing counsel, I'll take care of it. I don't know where all that feedback's coming from, Jeff. I think it must be from the field. Good morning, Officer Grant.
Good morning, sir.
All right, Mr. Bowditch, your appearance for Jesse Florenci. Sir, am
Your
I
Honor,
saying that correctly, Florenci?
Yes, Your Honor.
Thank you, Mr. Bowditch.
Your Honor, for the record, Jeffrey Bowditch, 45367, appearing on behalf of and with Jesse Florenci. Your Honor, today's a date and time set for arraignment with way forward reading standings. Ask the court to respectfully enter a not guilty plea on Mr. Florenci's behalf.
I'll enter a not guilty plea. We're looking at a probable cause conference date, August 18. That will be courtroom number 1. Mr. Florenci, I've got your address on Morton View. Is that correct?
Yes, Your Honor, 8260.
Yes, sir. Phone number 333-3517.
Yes, Your Honor.
Thank you. Mr. Bowditch, let's talk bond.
Your Honor, Mr. Florenci is a 31-year-old individual. He's presently employed at Bros. His address on Morton View is with his father. He does not reside with either of the victims in this case, the alleged victims. He's not on probation or not on parole. He did have a domestic violence approximately 6 years ago with one of the complainants. He's presently been incarcerated for 4 days. He has 3 children at home, one 11, one at 10, and one 3. I read the recommendations of of the police department as far as bond. I'm certain that Mr. Florenci could not make anything in that area of bond. I would ask Your Honor if the court might consider a personal bond with a strict adherence to no contact.
Not with this history, Mr. Bowditch. I cannot do a personal bond with this history.
I understand, Your Honor. I believe
Anything
there's
else for me to
also a
consider?
present case in Riverview.
Yeah, I think that's on the bond, right? All right.
Mr.
All right,
Florenci
anything
is
else?
not aware of that case, Your Honor, that he has told me.
Okay. All right, Mr. Florenci, I'm going to set your bond at $250,000, 10%. No contact with the complainants. If you are able to post with a bondsman or some other means, then there will be a house arrest with GPS tether. Understood? Oh, I muted you, sir. Give me a thumbs up if you understood that. All right. I did not say the time, Mr. Boggs. The time of the court date is 8:30 a.m.
Thank you, Your Honor.
Will provide notice to. You're welcome. Officer Grant will provide notice to Mr. Florenci. Case number is 210629. Mr. Florenci, do you have any questions for Mr. Bowditch before I terminate the call?
No, Your Honor. Your Honor,
Yes, sir.
Just wondering, did you give us a preliminary exam date as well, or we're not doing that?
No, we're just setting PCCs at this point, Tony.
Perfect, no problem, sir. I just didn't want to miss it.
No problem. Stay safe.
Yep, thank you, sir.
Thank you, Mr. Bowditch.
I think I've completed everything, Your Honor.
Yeah, if they come up with anything new, we'll call you.
Thank you, sir.
Would you let counsel know we're ready to go? Counsel, thanks for giving me the break.
Yeah, of course. Thanks for letting me have one.
Mr. Arvo, you're still under oath, sir. Thank you for letting me take care of that other business. Counsel, go ahead.
Thank you. Okay, sir, I am approaching with what's been marked as Exhibit J. Are you familiar with that document?
No, ma'am.
Okay, this is a document from the city of Romulus stating that it's a final notice. Is that correct?
I'm reading it for the first time, if you're saying so.
Yes, it says final notice on top, dated July 23rd, 2020. Is that correct?
Yep.
Okay, and the first paragraph says you were previously notified in a letter dated June 19, 2020, that it's been brought to our attention or the attention of this office that there are violations of the 2015 International Property Maintenance Code. Is that correct?
Yeah, I'm reading the letter, yes.
Okay. Okay, are you aware of any inspection that was conducted in June, July, or August by MISHTA on the premises?
What year, counsel? I'm sorry.
2020.
No.
While my client lived there. You're not aware of any inspections?
No.
Okay, I'm coming up with what's been marked as Exhibit K. Have you ever seen this document?
No.
Okay, this is what reads on top, an inspection deficiencies notice. Is that correct?
Yes.
And this is a document from MISHTA dated August 17, 2020.
Yes.
Okay, and it says to the landlord, If the tenant is already on the program, repairs must be completed and verified by the correction deadline, or Mishta will stop payments, parentheses, abatement, period. Abatement will begin on the first of the month following the correction deadline. Abated payments are lost payments and cannot be collected from the participant or Mishta. Is that what that says?
This is the first time I'm seeing this letter. If you're reading it, yes, it might be
Okay.
correct.
And on page 2 of this exhibit K, it lists a number of deficiencies which you are not aware of. Is that correct? Okay. Did you ever come to find out that in fact rent was being abated by Mishta?
No.
Did you ever receive a
Counsel.
stop payment notice?
You okay, ladies?
My mother,
You need a break?
Judge, we need to get this over with. My mother is ill and she has some things that she needs to testify and talk about that she witnessed going on too, but I don't know, if she can, are you gonna be okay? Can we get through this? Okay.
And ladies, if you need a break, just let me know.
Well, she has to go to dialysis shortly, so it's
Okay.
like we're on the time frame.
Okay.
I don't need too much longer.
Okay.
We're almost through this. Okay. Okay, sir, did you ever receive a stop payment notice from Mishta?
No.
Okay, I'm coming with Exhibit F. Are you familiar with this document?
No.
Okay, and this is dated August 20, 2020. It's a stop payment notice by Mishta, is that correct?
Yes.
Okay, first paragraph says your Mishta rental payments have stopped due to the housing quality standard deficiencies listed on the attached inspection deficiencies notice. Is that correct? Okay, and the effective date there is September 1st, 2020?
Yes.
Okay. Were you ever, sorry, strike that. Did my client ever send you any notice or any communication that she would be abating her rent due to the condition of the premises?
No.
Never. Okay. We'll move on to rent. Does your company keep records of rents charged, amounts owed, things like that? Do you maintain a ledger?
Yep.
Can you tell the court how you track rents?
We track the rents through bank statements and the rent deposits.
Okay. And you are the person who has personal knowledge regarding rent payments made and not paid. Is that correct?
Yeah.
Okay. What payments, if any, did you receive from my client?
I've already produced that ledger, which I will not be having right now. Do we have a copy?
Do you remember the total amount paid by my client?
Your client has to pay payment. The direct payments that we receive from your client would be the security deposit amount.
Okay, which was how much?
She had paid 3 check payments, which I've given this.
Do you recall the amounts?
I would not be able to tell you unless I see the record right.
Do you have an estimation in terms of whether in the hundreds or thousands of dollars my client's rent
Your
payments?
client, I think, has paid maximum about $1,800 in rent.
Maximum $1,800? Okay. What about Mishta? How much payments have you received from them?
The only payment I received from Mr. would be sometime end of July. Only one single payment of $3,500 and plus one more payment after that. After that, I have not received anything from Mr.
Okay, I am coming with Exhibit M. Are you familiar with this document?
Yeah.
Okay, this is the complaint that you had your attorney file, is that correct?
Yeah.
And how much are you alleging the outstanding rent?
16,425.
Can you tell the court how you arrived at that number?
This number has come from the $1,300 lease.
Okay.
Into the number of months. And that notice period would be sometime in 2021, and it should be in April of that month.
Okay, so how many months do you allege rent was not paid?
It was about 16 months.
From when to when?
From January of 2020 till the April when the notice was sent out.
Okay, when did my client move into the property?
The client moved into the property, she took the official position of the property on 1st of February.
1st of February?
Yeah.
Okay, so, and you recall that February lease that I showed you?
Yeah.
Right? Okay, so why are we charging her for January rent?
Why are we charging for January rent? Because the house was locked in for a month due to the process that we had to go with RPA management. Of they coming, checking up, going. The lease was signed, but we were not allowing anybody else because the process was taking that time.
But that lease was not accepted, so that lease was voided. Do you agree with that?
You are putting what we were doing as a support to your client as my blunders. Statement corrected. See, all these things was a lease signed. We went through this process. The client needed help to get rent from Section 8, and we had to go through all this process. And today, you're trying to use that against me, which is not right.
Okay, I was just asking why you're charging my client for a month of rent when she didn't live on the property, nor was that earlier lease agreement accepted by Mishta, and the later lease date, which my client didn't in fact sign, began February 1st. So I was just inquiring why rent wouldn't start in
I just told
February.
you, we were there, the house was there for 1 month for them to go through the inspection process and everything.
Okay, so you stand firm that my client owes you $16,200 or $425 in rent?
I would say, state this, I have no document to show, or I have no proof of you moving out of my property.
Okay.
Even today, as far as I have on record, my property is not handed over back to me.
Okay, so let's assume that you're correct, that the tenancy began in January. And you're saying that the rent amount is $1,300, is that correct?
Mhm.
Did you not agree to accept $1,002?
Did your client tell you for the?
Sir, yes
Yes,
or no?
yes.
Okay, you agreed to accept $1,002, is that correct? So let's say.
Not in principle, ma'am, that's what I'm saying. When you say, make a statement, she has signed one more document where she said she's going to pay the balance money to Haggerty Holding, the difference in lease amount.
Okay, so the lease was modified to $1,002, and you're saying she signed a separate document which says she's gonna pay more than that?
The lease was for $1,300. We have corrected a lease for $102 for Section 8 purpose. The difference in the lease amount she was supposed to pay.
According to what document did my client
I will
agree
put
to
that.
pay more than what the lease stated?
Well, it was one of the documents you handed them that said Mr. would pay 1,002, she would pay
No,
two something.
the total payment was $1,002. Mishta would pay $720. She would pay $282.
Correct.
Correct. Okay, I'll move on from that, but I do want to let you know that 16 months times $1,002, if we're seeking the full amount, is $16,032. That's the total. If your version of facts is correct, that's the maximum that you would be entitled to,
I
according.
put it this way. I have not, today, I'm not looking at 16, 14, or 15. I'm only looking at what is the amount that your client is going to pay for occupying the house. It's simple as that.
Are you aware of any law or regulation that says that when Mishta owes you a portion and they don't pay it, you can come collect that from the tenants?
No.
Okay, so you're just charging the whole rental amount against my client, even though it's Mishta who began abating rent due to what is essentially your fault?
Yes or no?
No.
Okay, I'm coming forward with what's been marked as Exhibit N. Are you familiar with this document?
Yeah.
Is this your handwriting?
Yes.
Okay, this is a payee authorization, is that correct?
Yes.
Okay, and are you familiar with that bank account information?
Yes.
That's there. Is that Haggerty Holdings bank account number?
Yes.
Okay. Okay, and you say you only received one payment from Mishta, is that correct?
Yes.
Okay, I'm coming forward with Exhibit O. This is a Freedom of Information Act request regarding housing assistance payments. Have you ever seen this ledger before?
No.
Okay, This is the Housing Assistance Register Resident. This is a document which lists all of the payments that were made to Haggerty Holding Corp. Is that correct?
I'm seeing this ledger for the first time. I can give you the proof of entries. There are only 2 entries that I have in my bank from Michigan State for the renter. What you're showing me is a ledger. A ledger can be any amount. It is not the payment.
Okay, so this is a FOIA document which states that Mishta made $4,638 in rental payments to you.
Can you give me, support me a proof showing me this payments were made to my bank account, which you just showed?
This is the date the payment was made.
Ma'am?
This is for who? It says for Yolanda Elaine.
I want a
And then it
bank
says the
authorization.
payee is Haggerty Holding Corp.
Simple, ma'am. All I'm asking is, can you show me a bank authorization which shows that's a ledger?
Okay.
Show me a proof of payment.
But you filled out that payee authorization with.
So
your bank
I'm trying to tell you, I have only 2 entries in my bank account.
Okay, so that ledger, are you saying that those were not made, those payments of 4,000 and some dollars
And the
were not
standard
made to your
accounting practice is a
account?
ledger is different from bank authorization.
Okay.
I need a proof the
Mr.
payment
Revelle,
came to my
Mr.
bank.
Revelle, is that yes?
No.
You're saying you didn't receive all those payments?
No.
Okay, you didn't receive $4,638 for Yolanda Elaine Walker Upshaw from Mishta. Okay. I'm coming forward with Exhibit P. Sir, are you familiar with Fidelity Information Corporation?
Yeah,
Okay, who are they?
the credit companies, collection company,
Okay. and
I'm
how-
sorry, I didn't catch the answer. Who are they?
the collection, rental collection.
Collection company, okay. And what is the date of this litigation notice?
October 17th?
Okay, and this is sent to Yolanda?
Yeah.
That's my client, is that correct?
Yeah.
Okay, as of October 17, 2020, what is the total amount due according to this litigation?
6,875.
Okay, so.
I'm sorry,
6,000.
hold on. When you both speak, I can't hear. So you asked him how much the total amount was, and you started talking when he did. So how much is the total amount that
6,875.
6,875. Thank you.
Can you tell the court how, from October 17, the amount outstanding went from 6,875 to 16,425?
You're asking me a question. In October, the outstanding rent, when the notice went to them, is somewhere around 17. And the outstanding would have been from the previous months. And I have not received any rent till today. The whole of 2021, I didn't receive any rent.
Did you ever contact Mishta about how it is that you received 0 payments during this entire tenancy?
I have communication with my attorney who's going to give it to you. And that communication will go on file. The only communication we had was in July. In August, they paid us the money.
Okay, did they ever explain, our ledger shows that we paid, 4,000 some, how is it possible that you have nothing from us? Did you ever have that?
The simple thing, can you ask RPA Avista to give me the 1099 for 2020 and we'll account for it. Whatever is the balance, you can pay us.
When did you notify Ms. Walker that she was in default?
She was informed in the March of 2020 to move out of the property for default of rent.
And you didn't file an action until April of 2021?
Because we went through the COVID crisis, the whole COVID has taken this issue.
Okay, and again, did you contact RPI or Mishta about the payments that were never received?
Yes.
And what did they say?
Again, I just informed you. My communication started sometime in July. They did some bank updates. The first payment I received was in August, and that I had to receive 2 payments from Michigan State, 2 entries.
Okay.
After that, I have not received any.
And then when you did you ever learn from Mishta that rent was being abated starting September due to the condition of the premises?
We are all aware, ma'am, it was a COVID situation. My office is not a big company. There are 3 people who work. Communication would have come, I would not have received, but I have not received. Time and again, I'm telling you, I have not received it.
Okay.
And emails, I have not received it. They were communicating.
So that was no?
No.
You never, until this day, you never learned that rent was being abated?
No.
All right, do you currently have the keys to 9459 Essex from my clients?
No,
You never received the keys
No.
from them?
No.
Okay, I know you've already questioned the authenticity of this document, but I'm showing you Exhibit Q. This is a letter dated February 6, 2021, is that correct? Okay, and it says, I, Yolanda Walker and Judy Watts have vacated the property at 9459 Essex Street in Romulus. I have enclosed the key to the Essex property. You never
you're
received
attorney,
this?
right? I have communication from your client in certified mail 3 times last year.
Okay,
But when she has vacated the premises, I have a letter from you which does not show how I received it, not even a postal mail. And you said I would receive the keys.
Okay.
So that's what I'm asking.
understood.
A simple thing, I want to make a statement.
Understood, and I'll ask my client about that. Do you have any idea when it was that she actually did
I'm not
leave?
aware of it. So.
Do you have, would you dispute that she actually left in
I
February?
am not aware of it until the court process started.
Did you ever come to the premises and
No.
see that someone was or was not living there?
No.
Okay. Okay, I haven't marked this one, we can mark it. This is a demand for possession, is that correct?
Yeah.
Okay, and this is dated March 18, 2020? How did you serve this document?
This was sent in an email. One was sent to RPA management, and one was through the email to her.
So you emailed this to her. Yeah. And this is another demand for payment, which is dated, essentially you're certifying that you served my client with this demand on January 2nd,
This was sent to the door.
I'm sorry?
This was sent.
Okay, you've marked that you delivered this personally, is that correct?
It's not me.
Isn't that your signature
Yeah.
right there? Okay, so
It was.
that you delivered it personally?
Yeah.
Okay. And it says that you also delivered it by mail, is that correct?
Yes.
Okay. If my client says that she never received this, would you dispute that?
I don't know.
But yet you say that you served it personally on her?
Yes.
Okay. I don't have anything further for this witness.
Redirect.
Yes, yeah. Mr. Arvell, you still have Exhibit 1 in front of you?
Yep.
And that's the one that was signed by you and signed by Miss
Yolanda.
Yolanda Walker. I'd move for entry of Exhibit number 1.
Any objection?
Nope.
Exhibit 1.
With
One will come in.
regards to,
That, let's, just for the record, plaintiff's number 1.
correct, it's marked as plaintiff's Exhibit 1, Judge, thank you. There is documents showing that Mr. was supposed to pay $720 per month, correct?
Yes.
There's also documentation showing that the last payment they were gonna send to you was in August of 2020, correct?
I didn't receive the document.
Did you receive any payments from Mr. in September of 2020?
No.
In October of 2020?
No.
In November of 2020?
No.
December of 2020?
No.
January of 2021?
No.
And February of 2020?
No.
With regards to, again, there's some documentation that the defendants were to pay you $282 per month if you were getting, if we were using the 1001, correct?
Mm-hmm.
Is that, yes?
Yes.
There's some documentation that shows they stopped paying in May of 2020. Does that sound about correct?
Yes.
So did you receive any payments from the defendants from June of 2020 through February of 2021?
No.
And again, the documentation shows $282 per month even though, again, your claim is they still were obligated to pay the full 1,300.
Yes.
Nothing further, Your Honor.
I want to call my client.
Nothing further from Mr.
Not
Rowe.
for
All right,
this
sir, you can
witness.
step down.
Thank you, sir.
Go ahead, I'm ready.
Okay.
Watch your step, man. Raise your right hand for me. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth today?
I do.
All right, settle in, make yourself comfortable, state your name.
Thank you. My name is Yolanda Walker Upshaw,
Ms. Upshaw, how old are you?
57.
Okay, and did you reside at 9459 Essex Street in the city of Romulus?
Yes, I did.
Okay, who did you live there with?
I live there with my mother, Judy Watts.
Okay, and how old is she?
My mother is 77.
Okay, how did you come to reside at that property?
I was given the phone number of a gentleman by the name of Bob Vora and several other gentlemen that were renting property in the Romulus area. I wanted to move from an apartment to a house because my mother's wheelchair bound and it would be easier for her to get around. And so when I called Mr. Vora said, no, I'm not into the rental properties anymore, but I'm going to give you the number of someone who is. So I contacted Arvell Kishner. He says, I have a property over here on Washington Street for you. So I came out and I looked at the property. It kind of fit the bill, the open floor plan for my mother's wheelchair. So I said, okay. But unfortunately, I guess I missed out on that. And so when I called him back, he said he had already rented the property, but he has another one on Essex for me. It's not ready yet, but it should be ready in a little while.
Okay, and what is your understanding of how the process works in getting federal assistance for rent?
I've been on HUD since 2015, Section 8 rather. And so when my mother got sick and I had to take care of her, I added her onto my voucher. So I think my voucher was something like $1,197. So when I approached him about the Essex property, he says, well, come out and look at it. I took a look at it. It was kind of small, but I was like, well, it could probably work. It would be better than the apartment that we were in. And so that's how we came into contact. So what HUD gives you, or Section 8 rather gives you, you have a move packet. So I submitted the move packet to Mr. Kishner, and it had all the information in there about the amount of my voucher and different other aspects of the program and the paperwork that he needed to sign. It's called the Landlord packet.
Okay, and in that packet that had a December 4, 2019 lease?
Originally it did, but because the inspection had not been done, there were several things that were going on. The lease was void because number one, it didn't have the right amount on it. It had originally had $1,300 on it, and HUD was only going to pay the $1,002.
Okay, I am showing you what I showed the earlier witness as Exhibit D. This is the lease dated February 1st, or the lease for the term beginning February 1st, 2020.
Yes, that's the lease.
Okay, and that lease amount is for $1,002 a month?
That is correct.
Okay, and was that the lease that was approved by MISHDA or RPI?
Yes, it was.
Okay. Did you sign that lease?
This one, I don't think so.
Okay.
I don't think this one was signed because he said I didn't need to sign it, and it wasn't, when he presented it to me, he said, I didn't need to sign it, don't worry about it.
Okay.
So I didn't sign it.
When did you move on to the property?
I moved on the Essex property. I think we moved in, he turned the keys over February the 4th, 2020.
Okay, prior to you moving in, how much did you pay?
I gave him what was required of me, which was a security deposit, which was $1,950. That was the original amount based off of the $1,300.
Okay, and did you make any other payments with that security deposit payment?
I paid my portion of February's rent.
Okay. Which was the $282?
That is correct.
Are you aware of any inspection being conducted on the property prior to you moving in?
Yes, there was some deficiencies that were going on that needed to be corrected. I'm not for sure of the ones, but the one that sticks out with me was the regulator on the shower. That was holding up the inspection, and I think there's some documentation to show that it still needed to be, that it was finally approved.
Okay.
And it wasn't repaired. What they did was they turned the water pressure down in the basement to simulate that the shower regulator was repaired. So it wasn't repaired.
Okay, are you aware of the landlord having obtained a certificate of compliance and or a certificate of occupancy prior to you moving in?
No, not prior to moving in.
Okay, describe the condition of the premises after you moved in.
Things began to happen shortly after I moved in. One of the things that happened, and also I submitted pictures of it, the basement began to back up. It started backing up the first time. Okay. I know there are like 4 huge trees on property. I used to be a property owner, and I understand that things have to be, roto-rooted and maintained, their sewers and their trees. That happened, and then he sent someone out to irrigate it. Next weekend, when I went to go wash and put a heavy load on the system, it started backing up again. It was just like every Saturday for the first 3 weeks that I moved in, I had an issue. So upon the third time that the basement backed up, he sent a gentleman out to snake out the drain. And the gentleman informed me, the gentleman was from King's Excavation, and he informed me that he told him that the sewer line was so damaged that it would have to be repaired. He was.
Okay, what other conditions existed on the premises?
So there was a leak up under the kitchen sink that was repaired with duct tape. And so when I discovered the leak, it was probably sometime into my, my renting the property. It leaked all in the kitchen. It affected the wall in the back of the sink. It began to grow black mold. I submitted pictures of that. I also submitted pictures of the duct tape on the pipes.
Sorry, when you say you submitted pictures, you mean to?
I submitted the pictures to the landlord as well as to you and to HUD.
Okay. What other issues?
Besides the black mold and the leaks in the kitchen, also in the bathroom, when they tried to repair the shower regulator, they punched a hole into the one of the pipes. And so when you take a shower or run the bathtub, it would leak. As a matter of fact, the leak was so bad that it started leaking into my mother's room. And I submitted pictures, and also HUD detailed it in their inspection of the damage to the bedroom wall and to the cracks and stuff. And he also noted and also took pictures of the duct tape that was used to repair the leak.
Okay. Were there any electrical defects?
Definitely. The microwave went out. And so when the microwave went out, I said, this is a brand new microwave. Let me call Whirlpool. Whirlpool guy came out, and he was shocked at what he found. There was an extension cord with a light on it that was ran from the fuse box in between the wall. And I guess they drilled the hole and put the cord from the microwave and connected the extension cords together inside the wall.
Okay. Were there any issues in terms of living creatures, mice, termites?
Oh, yes.
Anything like that?
The basement is riddled with termites. What they did was they painted over the termite mounds in the basement. You can see the cracks from the termites. Termites come in, water comes in. The basement steadily stayed damp. The central air system was messed up, which caused it when they moved the utility tub from one side to the other. They didn't rehook all the condensation and all the stuff that comes from the central air system. So it started leaking in the basement. So I had the leak from the tub, I had the leak from the kitchen, and I had the leak from the central air system. Central air system, which is also, I provide a document of that. I had a gentleman from RTB Mechanical come out, and he could verify, what was going on.
Are there any other conditions on the premises that we didn't discuss?
Trash, it was littered with construction debris. They were supposed to clean it up. That was one of the violations that the city of Romulus had noted. Construction debris all throughout the yard, cement that was dumped in the front yard that had to be broken up and removed, chunks of cement that were strewn throughout the yard. So I could even have a company come out and cut my grass until we went through and moved all the chunks of cement. He installed a wheelchair ramp for my mother, but the pitch was so bad that it was dangerous for us to go up and down it. The only way that my mother could come in out of the house was through the sliding glass door. Well, the sliding glass door was inappropriately put in, so sometimes it would stick and you couldn't open the door, the sliding glass door. So we have the sliding glass door issue. We have the rotting wood and stuff from the leaks because the gutters weren't maintained. All of this contributed to a lot of what was going on in the basement. It was just like I said, I think the scariest thing was the fire hazard from the extension cord in the wall. I just couldn't sleep well because how would I get my mother out this house if that wall was to catch on fire? Because that's our exit both ways. That was our exit out the back. That was our exit out the front. And as far as that porch being tore up, that porch stayed tore up for almost 3 months. I sent numerous letters to the city begging them, please help me with this, because at the time, Mr. wasn't doing their inspections, but the city did send inspectors out, and that's how we got them involved in it.
Okay. So you stated you notified the city of Romulus and the Housing Authority of these violations?
Multiple times. The city of Romulus, I sent like 5 emails to them.
Okay, I'm coming with what I've marked as Exhibit R. Do you know what this document is?
This document are the series of emails that I sent to the city of Romulus about my plight, the seriousness of it, how I was concerned, how the landlord didn't get back with me, and I was hoping maybe that they could persuade the landlord to come out and to make the repairs.
Okay, what is the first date of the email you sent?
The first date, I believe it goes back, it might
Sorry,
be,
it's not in chronological order, it's
Let me look.
back to front.
It was April the 3rd.
Okay, and who did you send an email to?
I'm sorry, April the 3rd, what year?
2020.
Thank you.
And
just to clarify, that's 2 months after you moved in.
Yes, that is correct.
Okay, go ahead.
I sent this to Robert McCrate at the Romulus government, gov.gov.
Okay, did he eventually respond to you?
Just asking me, let me see, what was the response I think he sent me back? He says, I will look into the matter ASAP.
Okay, and then when was the next time you reached out?
I reached out again, I think this is again, April 6th with some information on who the person was that, who they should contact the landlord. And that was, Arvell Kishner. I gave them the information. And then, let's see, I think the next time was I did May 2nd.
Okay, can you read that email?
It says, once again, I'm reaching out to the city of Romulus for help with the current condition of the rental property which I reside at. The landlord, Arvell Kishner, came out on Tuesday and said repairs on the property would begin on Saturday. It is now Saturday afternoon and no one showed up. To make matters worse, there's a massive leak in the kitchen and bathroom, which he has been aware of for some time. Mold is beginning to grow and I'm being overrun with critters like silverfish. I moved here in February with my wheelchair-bound mother who has renal failure, heart disease, and I asked that these repairs be made for health and safety reasons. My request fell on deaf ears. After sending a picture of the mold, I was told that my information it was not mold. I know mold when I see it. I realize the pandemic has been an issue, but the repairs were known about weeks before the stay-at-home order was declared. I believe this landlord is using the pandemic as an excuse not to make the repairs because I contacted the city. I have a text message to support this. I can't move at this time, so I have to rely on the city to enforce this matter. Please reply and let me know what the city can do to make this landlord comply. Sincerely, Yolanda Walker.
Did you get a response to that email?
No.
Did you follow up again?
I did on May 15th, 2020. I says, good morning, Mr. McCray. I continue to have issues with this landlord over the repairs and the condition of the rental property at 9459 Essex. The over-the-range microwave oven went out, and so I called the Whirlpool repairman out. He discovered that the microwave is hooked up to an extension cord inside the wall, and the plug came apart. It is not cold and a fire hazard. The second issue is they made repairs to the kitchen sink by drilling a hole in an existing pipe to drain the water that the pipe is for the laundry tub. Now I can't wash because the weight of the water in the pipe is so great that it pulls the elbow joint away from the bottom of the utility tub.
I am requesting that when it is possible to have a city inspector come out and go over the electrical and plumbing violations in this house. I'm very concerned about our safety. I am dotting my I's and crossing my T's because if something should happen because of faulty workmanship, I will have documentation that I tried numerous times to contact the city and landlord. This is a serious matter, and I hope you will feel the same way. Sincerely, Yolanda Walker.
Okay, from the time that you resided on the property, approximately February of 2020 until you left in February of 2021, were any of the issues or complaints that you stated addressed in any way?
No, it was completely ignored.
Okay, I'm coming with what's been marked as Exhibit S. Are you familiar with this document?
Yes, I am.
Okay, can you tell the court what that is?
This is what I sent to Joy Peters at RPI. At the time I was in a housing program, and so my housing counselor recommended that I send RPI a notice about what was going on. It says, "Good morning. I'm writing to inform you that I have put the rent in escrow starting June 5th, 2020. The landlord is refusing to make the necessary repairs. I was told I have a sense of entitlement and that he is not at my beck and call. The basement has leaked since I moved in. The basement has backed up with sewer 3 times before he corrected the problem. The central air was wired wrong and caused the repairman some concern. The over-the-range microwave was connected to an extension cord in the wall, which is a major fire hazard. I don't have the energy or the desire to fight this landlord over his gross misconduct and violation of my rights. I'm looking to move ASAP and would appreciate any advice or help in this serious matter. The landlord says he has not received a payment from you since I moved in and that I am responsible for the amount. So he claims February's rent towards January's rent, even though I moved in February. Please advise. Sincerely yours, Yolanda E. Walker."
Did you, after you sent that email or any time before, advise the landlord that you would be abating your rent due to the
Yes, I
condition of the
did.
premises?
Yes.
Do you recall when?
This was May 25th. I remember it exactly because the heating and cooling system had went out, and it was about 85 degrees in the home.
Okay, and it was pursuant to your request that MISHDA eventually came to inspect the premises, is that correct?
That is correct.
Do you know if the home passed the inspection standards?
No, it failed.
Okay. Do you know if the premises were, met those qualifications after that inspection was conducted?
No, it did not meet the qualifications.
Okay. Are you aware that MISHDA began abating their portion of the rent also?
Every notice that they send to the landlord is sent to me.
Okay, so you became
Yes.
aware that rent was abated?
Yes.
Okay, and did you speak with anyone about that at MISHDA?
They told me to move.
Okay.
That was they said to get out and to move because of the conditions that were in the home.
And we've already introduced those, but the MISHDA documents state that the landlord can't charge you the portion of the rent that they're also abating. Is that correct?
That is correct.
So you and your housing program were both abating rent due to the condition of the premises.
That is correct.
Do you recall how high the balance of your escrow account got?
Before I closed the escrow account, I think it was somewhere in the neighborhood of 1,800.
Okay. Did you make repairs to the property yourself?
Yes, I did. I had to.
Okay. So you took matters into your own hand. I'm showing you Exhibit U. Do you recognize those documents?
Yes, I do. The first one right here is I had someone to come out and take a look at how they could rectify the leakage in the basement. And so I paid for that. This is another one is from RTB Mechanical. If you'll note it, it says they had to run a new condensation drain from the pump to the wash tub because they moved the wash tub and didn't replace it. So that was one of the leaks that was rectified. Another one was to replace the power switch. On the receipt, he says all 3 calls were due to sloppy install of the furnace. Just another one was the voltage wiring was done incorrectly, and so he had to do the repairs. So yes, I did. And I also had a gentleman come out and put extra support on the wash tub piping so that it would not, pull away from the tub and leak onto the floor when I washed.
If you don't have an exact figure, can you estimate how much out-of-pocket expenses you incurred for repairs?
Probably altogether about $600. And that's not even including the removal of the cement that was dropped in the front of the yard and the chunks of cement in the back.
We'll move on to rent. Okay, what date did you vacate the premises?
We closed on the house February the 2nd. We moved into our new house February the 6th.
Okay, beginning on February 2020, when you moved in, what, if any, rental payments were made by you
To
Haggerty Holding?
none.
You didn't personally make any payments to Haggerty Holding?
After 20.
No, from when you moved in.
Oh,
February
yes,
2020.
most definitely.
Okay, what payments did you make?
I started off with $1,950 security deposit. And then, like I said, I began paying him because he kept harassing me and calling me, telling me that Mr. hadn't gotten money. So I would always pay extra. I can't remember. I made payments $658. I made payments for $300. They were kind of broken up.
I'm coming to you with what's been marked as Exhibit T. Can you tell the court what those documents are?
Okay. These are receipts, and I either get them from the post office so that I want them to be, tangible and, especially in a court of law. There's a receipt that I paid Haggerty Holding in the amount of $500. There's a customer receipt in the amount of $685. And here I have a money order drawn under my bank, Citizens Bank, $198. I have another drawn under Citizens Bank for $450. And then that's the $1,800 for the part of the security deposit. Under my mother's checking account, a check was written for $150. A check was written for $300. A check was written for $400. And on April the 5th, a check was written for $684.
Do you know if those checks were cashed?
Yes, they were.
Okay, so I'm just gonna do the math real quick, unless you already have the number.
No, I don't.
That's 500 plus 685 plus 198 plus 450 plus 1800 plus 150 plus 300 plus 400 plus 684. Okay, that's $5,167 total payments made to landlord. Is that correct?
Yes.
Okay, are you aware of how much, what the total amount of payments Mishda paid for?
I think it was something like 4,700 and something. I'm not.
Okay, and what again was your portion of the rent that was supposed to be paid?
282.
Okay, 282, and you resided there for 12 months?
That is correct.
282 times 12 is $3,384. You paid more than what you were supposed to. Is that correct?
That is correct.
Okay. What was the last month that you paid rent?
May. I paid rent in May. And so when I talked to him about the heating and cooling system, I got some, telling me he's not at my beck and call. He's going to turn off his phone. Yeah. After that, I was like, that was it. And then when I called the repairman out and he told me what was going on with the heating and cooling system, I was like, no, this is deep. This is something else going on here.
So you started abating
in June.
In June. And you've paid all of your rental amounts prior to that?
Yes.
Okay. And in fact, based on the total amount that I just calculated, you paid more than what you were legally obligated to do under the contract.
That is correct.
Which you didn't sign, is that correct?
That is correct.
Would you have moved into this home and paid $1,002 had Mishda not been paying for a portion of the rent? Did you bargain to pay $1,002 or $1,300 in rent any month?
No.
Okay, so you didn't contract to be responsible for neither $1,300 nor $1,002?
No, that's illegal under my housing contract.
Okay. Did you send notice to the landlord when you were vacating the premises?
Yes, I did.
Okay, and how did you do that?
I sent it via mail. I sent him a mail with I only got one key for the house and I sent the key back.
Was it in a flat envelope or a yellow envelope?
It was in a flat business envelope.
Okay. At the time this complaint was filed, were you living on the premises?
No, I had been gone for approximately 2 months. How I found out that there was even a notice on the door, my neighbor, I still keep in contact with my neighbors. And my neighbor said, there's a notice on the door with your name on it. I said, a notice? I said, well, why is there a notice on the door? I said, I've been out of the place for like 2 months. And so I said, well, I think you just got my name on it. You better look at it. When I found out it was a judgment and the court date, I said, no, we're gonna have to deal with this.
Okay, and you never received either personal service or registered mail service of the complaint, the demand for rent, anything at all?
Nothing.
Okay, I have no further questions.
Cross.
Thank you. Did the landlord install a handicap ramp for you at the house?
The handicap ramp that the landlord installed it's off pitch and it's unsafe.
The question was, did he? Yes.
Yes.
Or no? And as a result, either because of the sewer backup or the installation of the handicap ramp, was the driveway dug up to fix that problem?
The driveway was not dug up.
You indicated you sent a number of emails to the city starting April of 2020, correct?
That is correct.
In fact, you read a couple of them to the judge, correct?
Yes.
Were those emails sent to the landlord or Mr. Arvell?
No, they were not.
What notification did you ever send to him in writing indicating there was a problem with the house?
I sent text messages to him. As a matter of fact, I emailed a letter to the owner, Bob Vora, about the conditions, and he told me to refer back to Mr. Kishner.
I'm sorry, you sent messages to who?
The owner of the home.
Which begs the question, who's the owner?
The gentleman that originally gave me his number, Bob Vora.
So you're understanding that Mr. Orville did not represent the owner?
No, my understanding is that he was an agent of the owner. Okay. Your Honor, it was a corporation owned by several people.
Go ahead.
Would you agree that Mishta was independent? They wouldn't take Mr. Arvell's side or your side?
I would say so, yes.
And you're familiar with their inspection dated August 11th, 2020?
I was there, yes.
And in fact, again, when asked by your attorney, there was a number of things mentioned in the Mishta report, correct?
That is correct.
For example, living room, wall condition, repair, replace molding around door, and reset door that keeps falling off track.
That is correct.
Something minor, but.
The door is probably about 75 pounds. It actually came off hook and fell on one of my grandchildren.
Does this report anywhere say anything about mold?
Where there's water, there's mold.
That's your.
Was that a yes or a no, ma'am?
No.
Thank you.
When were you told to move by Mishta?
I do believe the first signs when I first talked to my housing rep, she says you need to find you. That's when I sent the notice about the deficiencies. So June, officially, it wasn't until October of 2020.
But you stayed in the property through the beginning of February of 2021.
Sir, we're in the middle of a pandemic. There was no push rental property for someone who's handicapped.
Ma'am, I've got to treat you the same way I treat
sorry.
Mr. Arville. Yes or no?
Repeat the question, please.
Even though you had discussed or Mishta advised you to move out in middle of 2020, you stayed in the property until beginning of February of 2021, correct?
That is correct.
And again, I have this marked as plaintiff's exhibit number 2, but I believe it was a copy of the letter your attorney showed to you.
Mm-hmm.
Is that yes?
Yes, it is.
And again, it indicates that you were going to start putting the rent into escrow starting in June 5th of 2020.
That is correct.
And so is it safe to say you did not pay the rent for June of 2020, your portion?
No.
Did you pay it in July of 2020?
No.
did you pay any of your rent from July 2020 to February 3rd of 2021?
No,
And you're also aware that Mishta stopped making payments. Their last payment was August of 2020, correct?
that is correct.
And again, so Mr. Arvel or Haggerty Holding Corp. did not receive the $720 from Mishta from September through February of 2021, correct?
Yes, that's correct.
And again, you've seen, it might still be up there, what's been marked as plaintiff's exhibit 1. Can you verify that that's your signature on the very last page?
This is my signature for the original lease, which was canceled out by my housing contract.
Okay. But again, the subsequent lease that was produced by you was never signed by you, correct?
It was signed by, I was told I didn't have to sign it by your client. He said, don't worry about it.
Your attorney has produced invoices showing some repairs, and when I told him the repairs total about $400, okay? But I believe you indicated you spent much more than that. Is it 400 or is it much more than that?
Because there were also handyman issues, I paid $85 to a gentleman to come out and to secure the pipes so that it wouldn't leak. I also had to pay my lawn care man to bust up the cement that was poured out into the front yard, and also to haul away some of the cement chunks that were in the grass.
Did you produce those receipts or?
Produce them to who, sir?
Attached to your attorney, I believe, showed you several receipts.
I produced those to my attorney, that is correct.
Are you familiar with paragraph 20 of the lease?
What page would that be on?
Page 6.
Yes.
That indicates that if there's a repair that needs to be done that's less than 150, it's your responsibility, correct?
I see that, yes.
And it looks like, again, the invoice you submitted for Plumomatic was $49. Does that refresh your memory?
What about it?
You paid $49 to Plumomatic?
For the inspection.
Okay. And you paid, it looks like $130 to RTB Mechanical in July 7th of 2020.
Yes.
And again, to RTB Mechanical on August 27th, 2020, for
Yes.
$145. And then a third one to RTB Mechanical, it's not dated, for $130.
Yes.
Those are all under the $150 mentioned in paragraph 20, correct?
But they're all dealing with the heating and cooling system, sir.
I have nothing for you.
Yolanda, council characterized the deficiencies listed by Mishta as minor. Would you agree with that?
If they were minor, why would they cancel the housing contract?
Well, I was going to ask that. Are you
Yeah.
aware of, Mishta terminating a contract or abating their rent for quote unquote minor violations?
No, they wouldn't do that.
Okay. Did you receive your security deposit back?
No.
Okay, so once again, total payments you made and that the landlord kept $5,167.
That is correct.
And your total obligation under the contract, which I believe you're not a party to because you didn't sign it, is less than that amount.
That is correct.
Okay. With respect to the repairs of $150, is it your intention to deduct the amounts you paid from whatever rent obligation is allegedly owed?
Yes.
Okay. But I didn't calculate that into my figure of 5,167, did I?
No.
Okay. I don't have anything further.
Nothing further.
All right, any rebuttal?
Your Honor, I don't know.
Are you gonna put?
No, I'm not.
Okay.
Your Honor.
Ma'am, I'm sorry, ma'am, you can step down.
Okay.
Watch your step.
Thank you.
Can I just ask Mr. Arvell two questions?
Sure. Yeah. Just speak up just so we get you on the mic.
Mr. Arvell, did you ever receive notification that they had vacated the property?
No,
And did you in fact receive $5,167 from Ms. Walker?
no.
Nothing further, Judge.
Okay. Any redirect or recross?
I don't, Your Honor, other than the fact that we produced receipts and those.
Well, just so we're clear, I've only got one exhibit that's been admitted.
Oh,
And that
well,
was
then
plaintiff,
I
that
would
was
like
plaintiff's
to,
number one.
then I would like to move to admit all of defendants exhibits A through U, which I believe I left the stack up there in order.
You got some exhibits? I don't have any exhibits.
I left it right there by your gavel.
Oh, I thought that was number one. Any argument on those, counsel?
No, Your Honor.
All right, those will be admitted. Can I have the lease?
I believe that's
Plaintiff
my
number
exhibit.
one.
Right here.
Thank you. So we are in agreement, plaintiff number one and defense A through T, or A through U. That's it.
Yes.
Okay. Somebody help me out. Does the lease say who's responsible for the full amount?
Judge, again, exhibit one indicates that the tenants to pay $1,300.
And exhibit D is $1,002 with documentation B, C, and E showing what apportionment would be between Mishta and my client.
And that would be the amended lease that was not properly executed.
Correct.
All right. Anyone want to make an argument?
Yeah, Your Honor, can I just briefly? So again, even if we accept exhibit B with the rent being $1,002 per month, purportedly that was agreed to by the tenant, the defendants. Purportedly it was agreed to by my client because he signed it. There's nothing in here, a legal binding contract that deals with payments by Mishta. So the fact of the matter is under these situations, the tenant is responsible for the amount in the contract that she signed. Technically, the one she signed was $1,300, but even if we give her the benefit of the doubt, $1,002. Your Honor, also, Mr. Arvell testified he wasn't sure what payments she made, but we do know what payments were not made. And it's very clear from the testimony from the defendant herself, she did not pay her portion from June of 2020 through February of 2021. When I do the calculation, again, that's a simple 1, 2, 3, 4, 5, 6, 7, 8, 9 months at 282, we come up with $2,538. We also know with absolute certainty that Mishta did not pay since September through February. Their portion was $720. Again, we're dealing with September, October, November, December, January, February, 5 months at $720. Again, if my math was correct, that is $6,012. So even if we give every benefit of the doubt to the defendants, they still owe $8,550 based upon the contracts and based upon the admissions of what rent was not paid. So we're seeking a judgment for $8,550, Judge.
Thank you. Okay. As Your Honor is aware, plaintiff filed for $16,425. Apparently now that amount has been reduced, where at first Mr. Krishna testified that he received one payment from Mishta. I produced the ledger showing that more than $4,000 worth of payments were made. They've also argued that they received I don't know if they stated an amount, but I did produce the receipts showing that my client made upwards of $5,000 worth of payments towards rent, which exceed the maximum obligation that she would have to pay pursuant to the allocation between Mishta's portion of the rent and her portion of the rent. Your Honor, it simply just wouldn't be fair for my client to have to pay the balance of what Mishta failed to pay, which they were legally entitled to not pay based on the circumstances that existed on the property.
But what's the lease say? I don't want to talk about what's fair. I want to talk about what two adults agreed to.
Your Honor, two adults agreed to participate in a program to accept rent from Mishta.
But does the lease say that?
Well, the lease, I would argue, Your Honor, my client didn't sign a lease.
Well, let's talk about the one she did sign. Does that one say anything about a third party paying some of the rent?
I don't believe it does, but Your Honor, that was the lease that was not accepted by Mishta, and had that lease.
Mishta's not a part of any contract.
I agree with that, Your Honor, but nonetheless, my client would not have moved into that property.
But she signed the lease.
But she would not have lived there had she not been getting payment assistance. She would not have continued with the tenancy on that property had she not been receiving federal assistance for that amount. And in any event, I would argue that the rental amount is $1,002. Mr. Krishna himself signed the February lease. He acknowledged that that was the amount of the payment. And again, just because my client didn't pay after June, it doesn't mean that the total amount of the rent that she did pay did not exceed the obligation that she would have had to pay. It's a complete, I don't want to call it a lie, I'm not sure what happened, but Your Honor, the ledger shows that payments were made by Mishta. The receipts that I produced, certified checks, money orders show that the landlord did receive payment. Whether that was into a bad account or how it happened, I'm not sure what the explanation for that is. I'm not sure how those facts can be reconciled. But again, my client has paid more than her obligation. Her security deposit was not. She's
purchased money orders for more than her portion.
Correct. I guess I didn't ask her whether in fact those money orders which were drawn were submitted. I would assume that they were.
Or cashed.
True, that's also a possibility. And again, if we're not looking at all of that, just based on the condition of the premises and the fact that the premises continued to be in the state that they were, the fact that Mishta performed an inspection and terminated their own obligation to continue to pay rent, the emails which document that she complained of mold and other piping issues, electrical issues. Ms. Watts is an amputee. She can't even go up the ramp there. I think my client was definitely entitled to an abatement of rent, and due to the fact that no repairs were made up until the time she left, I just don't see how this landlord is entitled to anything at all based on those circumstances. They were aware, they got notices of everything. They never came out to make any of those repairs and to make this property habitable. The complaint that was filed you have to check a box to say that these premises were in a habitable condition, and I believe the evidence shows that it simply was not, and if it was, Mishta would not have terminated. Even the city of Romulus said that this was not up to par. There was no certificate of compliance. It's not legally allowed to even rent premises that don't have a certificate of compliance or occupancy. So this whole tenancy is in violation of city ordinance.
Which has no impact on what I do.
Correct, but that's just indicative of whatever you want it to be. Thank you.
Go ahead.
Briefly, Your Honor, the documents from Mishta didn't say they were terminating payment because of the conditions of the house. They were terminating the payment, if you look at the exhibits.
I haven't looked at them yet, but I will.
Because of the fact that the repairs were not done. They're not saying, hey, these repairs make the house unlivable. They just said, hey, you were supposed to repair the molding around the one door and it wasn't done, so we're going to discontinue it. It had nothing to do with saying the house is not livable. And of course, that's obviously our position that, yes, there may have been things wrong with the house, but none of them made it unlivable. Thank you.
Okay. All right. Thank you. Give me a minute. Let me digest all these exhibits. You can shut down for a minute if you want to.
the lease. So you have to have a special lease. So how can I die? Wait, no, so how do we come up with 18,000?
Because they're saying they never got anything. They never got any money.
From your wife?
Yeah, they said they got security money from you and one payment from them.
But all the money that I put in, all the receipts to that show.
They're saying you didn't get those.
How is it possible?
I'm gonna get some water.
Okay. I'll get to the car.
That's what they already did with the collections.
Yeah. Well, I backed it down because there was no judgment, so they can't go out my credit because there was no judgment, so they won't could go.
Well, we'll get a judgment now. We'll get a judgment now.
Oh, yeah. Yes, ma'am.
It's done?
No, I'm just started the process.
Okay. Don't finish it off until this judgment is on.
Okay.
Yeah. If there is one, which I hope there isn't, we'll see. I don't know. They'll gladly take the money. They'll gladly take the money out.
It's 11:50. Yeah, I see. Maybe 15 more minutes just to review the incidents. And I already highlighted them for him because I knew he would want to look at them. My boss called me.
Hey, give me a call. I'm over the exhibit on the horror matter with you. My number, you got it? Give me a call anytime. Bye now.
My number, my boss, of course I know his number. So according to, did you handle that amendment? But according to her, they can't go on. Oh, they pay me, late. But that doesn't even mean it. That's what he says. All this mess, which is money, because I'm like, it's like that violation of city ordinance. Like, it should indicate the fact that property. Oh.
Raise your eyes. Where's that session? Right up to the side.
Have a seat. Are you on? All right, thank you folks for giving me that time to review the exhibits. I am finding no cause of action, and I've been struggling with a nice way to say what I'm going to say, and I don't think I've figured it out, so I'm just going to say what I'm going to say. First of all, I'm looking at the MSHDA report from August 17, 2020, and that lists some things there that to me are more serious than just molding around the door. That's listed. Also talks about the leaking problems, also talks about the microwave with a extension cord buried in the wall. There are some issues here that are safety issues. There are some issues here that would make a house, if not unlivable, certainly uncomfortable to a great degree. And I know COVID has caused problems for everyone. And I know this came up right in the heat of the COVID mess, shutdowns and so on and so forth. But it's inconceivable to me that all of these various things that were sent to Haggerty Holdings didn't make it there. Letters from MSHDA, letters from the city, checks that were deposited, nothing made it to Haggerty Holdings. It's inconceivable to me, even with the COVID mess that we had. I'm not satisfied that Haggerty Holdings has clean hands in this matter. And for that reason, I'm holding no cause of action. I'll leave it at that. Anything else?
Thank you, Your Honor. Thank you.
Thank you all. Exhibits are ready for retrieval in 21 days. Give me a minute, I'm gonna do that basket work I brought into.
Thank you.
Quick magic.